Sale of Goods Act 1930, 6 parts: preliminary, formation of the contract, effects of the contract, performance of the contract, rights of unpaid seller, suits for breach. Preliminary: goods mean every kind of movable property other than actionable claims and money, includes stocks and shares, growing crops, grass and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. Future goods are goods to be manufactured or produced or acquired by the seller after making of the contract of sale. Specific goods identified and agreed upon at the time a contract of sale is made. Seller, a person who sells or agrees to sell. Buyer, a person who buys or agrees to buy goods. Deliverable state is such state that the buyer is bound to take delivery of the goods. Delivery means voluntary transfer of possession from one person to another. Formation of the contract and the contract of sale may be absolute or conditional. Absolute, when seller transfers property to the buyer for a price. Conditional, agrees to transfer for a price at a future time or subject to some conditions to be fulfilled. The contract is also called an agreement to sell. An agreement to sell becomes a sale when time lapses or the conditions are fulfilled. A contract of sale may be writing or by word of mouth, partly in writing, partly by word of mouth, may be implied from the conduct. Comparison parameters between sale and agreement to sell. Transfer of property in sale immediate, in agreement to sell at a future date. Goods, existing goods for sale, future goods for agreement to sell. Risk of loss of property on buyer in sale, on seller in agreement to sell. On breach, suit for price in respect of sale, suit for damages in agreement to sell. Right to resell doesn't exist in sale, but under agreement to sell, it is there. Right to enjoy the goods, just in rem against the world in sale, against a person in agreement to sell. Buyer insolvent before payment, only rateable dividend seller will get. He can refuse to deliver the goods when agreement to sell with the buyer insolvent. When seller insolvent before delivery, buyer can claim the goods as his own. Buyer can claim rateable dividend in respect of agreement to sell. Formalities of the contract. By an offer for a price and the acceptance of such offer makes a contract of sale. It may provide for immediate delivery or immediate payment or both, or for delivery or payment by installments, or the delivery or payment or both shall be postponed. Many options. Subject matter of contract, either existing goods or future goods. The price may be fixed by the contract or may be left to be fixed between the parties. Where price is not determined, the buyer shall pay a reasonable price based on circumstances. Conditions and warranties are stipulations with reference to goods, the subject matter. The stipulation may be a condition or a warranty. Condition is essential to the main purpose of the contract. Its breach gives rise to a right to treat the contract as repudiated, is however collateral to the main purpose. Its breach gives rise to a claim for damages. Where a stipulation is a condition or warranty depends in each case on the contract term. When condition to be treated as warranty. When the sale is subject to any condition to be fulfilled by the seller, the buyer may waive or elect to treat a breach as a breach of warranty. Where a contract of sale is not severable and the buyer has accepted the goods or part thereof, the breach of any condition can only be treated as a breach of warranty. An implied condition on the part of the seller that in case of a sale, he has right to sell the goods, and in case of an agreement to sell, he will have a right to sell the goods at the time when the property is to pass. Implied condition, sale by description or by sample. Goods shall correspond with the description. In a contract for sale by sample, bulk shall correspond with the sample in quality. Buyer shall have a reasonable opportunity of comparing the bulk with the sample, and goods shall be free from any defect, rendering them unmerchantable. In a sale by sample and by description, goods to correspond with both sample and description. Implied condition as to quality or fitness, an exception to caveat emptor, let the buyer beware, where the goods shall be of merchantable quality when bought by description from a seller who deals in such goods. If the buyer has examined the goods, no implied condition as to defects which such examination ought to have revealed. The goods shall be reasonably fit for such purpose, which is in the course of seller's business, and the buyer indicates to the seller the purpose why the goods are required and relies on the seller's skill or judgment. But in a sale of specific article under patent or brand name, no implied condition as to its fitness for any purpose. Implied warranty. On the part of the seller, an implied warranty is available that the buyer shall have and enjoy quiet possession of the goods, and the goods shall be free from any charge or encumbrance which is not declared or known to the buyer when the contract is made. An express warranty or condition does not negate you the above warranty or condition implied by the act. Effects of the contract. Transfer of property. Goods must be ascertained. No property in the goods is transferred to the buyer unless and until the goods are ascertained. Property in goods transferred to the buyer at such time as the parties to the contract intend. Rules in sections 20 to 24 relate to rules for ascertaining the intention of the party. Transfer of property in respect of specific goods. In a deliverable state, the property in goods passes when the contract is made. It is immaterial whether time of payment or time of delivery or both is postponed. When the seller has to weigh, measure or test or do some act for ascertaining the price, or he is bound to do something for the goods for putting them into a deliverable state, in such a case, the property does not pass until such thing is done and the buyer has notice thereof. In respect of unascertained goods, goods in a deliverable state are unconditionally appropriated to the contract by assent of the buyer and seller, and then the property passes to the buyer. Where a seller delivers goods to the buyer or to his bailiff for transmission and does not reserve right of disposal, he is deemed to have unconditionally appropriated goods to the contract. Goods sent on approval or on sale or return basis, the property passes when he signifies his approval or acceptance to the seller or does any other act adopting the transaction, or on the expiration of time if fixed for the return of the goods, or on the expiration of a reasonable time if he retains the goods without giving notice of rejection. Transfer of property. Risks prima facie passes with property. Unless otherwise agreed, goods remain at seller's risk. But when property is transferred to the buyer, the goods are at buyer's risk whether delivery has been made or not. Where delivery is delayed through the fault of buyer or seller, the goods are at the risk of party in fault. Sale by a person who is not the owner and who doesn't have the authority to sell. The buyer acquires a title as good as that of the seller, provided he acts in good faith and has no notice that the seller has no authority. A sale by a mercantile agent falls under this category. Sale by one of the joint owners who has possession by permission of the co-owners. Property in goods moves to the buyer, provided the buyer acts in good faith and has no notice that the seller has no authority to sell. Third category, sale by person in possession under avoidable contract, where the contract has not been resigned at the time of sale. Buyer acquires good title for good faith and without notice. This is seller or buyer in possession after sale delivers or transfers the goods or documents of title. The person receiving in good faith and without notice acquires a good title. The four instances are instances of sale by non-owners, nemo, dat, quod, non habet. In addition to these four, sale by unpaid seller and sale by official liquidator, finder of goods, pawnee or court receiver comes under the transfer of title in respect of sale by non-owners, where he can give a better title than what he himself has, as an exception to the principle of nemo dat quod non habet. Performance of the contract. Duties of seller and buyer. Duty of seller to deliver the goods and duty of buyer to accept and pay for them as per the contract of sale. Payment and delivery are concurrent conditions. Seller shall be ready and willing to give possession in exchange for price. Buyer ready and willing to pay the price in exchange for possession. Rules of delivery. Delivery is done by doing anything which has the effect of putting the goods in the possession of the buyer or his representative. The seller is not bound to deliver goods until buyer applies for the same. Goods sold are to be delivered at the place they are at the time of sale. Goods agreed to be sold are to be delivered at the place they are or produced. Seller delivers a quantity less than the contracted, the buyer may reject. If he delivers larger than contracted, buyer may accept as per contract, reject whole or accept whole at contract price. The buyer of goods is not bound to accept delivery by installments. If the seller delivers goods to a carrier or wharfinger as per contract, it is deemed to be a delivery to the buyer. Right of examining the goods. Where buyer has not previously examined, he has a reasonable opportunity of examining them before he accepts. Where seller tenders delivery, he is bound to afford the buyer a reasonable opportunity of examining. Acceptance is when the buyer intimates seller that he has accepted them. Goods delivered, buyer does any act in relation to them inconsistent with the ownership of the seller, or after a lapse of reasonable time retains goods without intimating seller that he has rejected them. Neglecting or refusing delivery. When the seller is ready and willing, requests the buyer to take delivery and the buyer does not within a reasonable time take delivery, he is liable to seller for any loss occasioned by his neglect or refusal, and also liable for a reasonable charge for care or custody of the goods. Rights of unpaid seller. Unpaid seller is the seller of goods when the whole of the price has not been paid or tendered to him, or when a negotiable instrument received as a conditional payment is dishonored. Unpaid seller's lien. The unpaid seller who is in possession of the goods is entitled to retain possession until payment of price, where goods have been sold without any stipulation as to credit, or where the goods have been sold on credit but the term of credit has expired, or where the buyer becomes insolvent. Where an unpaid seller has made part delivery, he may exercise his right of lien on the remainder. When the buyer lawfully obtains possession of goods, the unpaid seller loses his lien. Unpaid seller's right of stoppage in transit, where the buyer becomes insolvent and the seller resumes possession of the goods, as long as the goods are in the course of transit, and he may retain them until payment of the price. Goods are deemed to be in transit until the buyer or his agent takes delivery of the same. If the buyer or his agent obtains delivery before their arrival at the destination, the transit is at an end. Where carrier or bailee wrongfully refuses to deliver, also transit is deemed to be at an end. Stoppage effected by taking actual possession or by giving notice of his claim to the carrier or other bailee. Once notice is given, the carrier or bailee shall redeliver the goods according to directions of the seller at his expense. Where property has not passed to the buyer, the unpaid seller has a right of withholding further delivery. Effect of subsale or pledge by buyer. Where a document of title is transferred to any person as a buyer of goods and he transfers the document to another person who takes the same in good faith and for consideration. In such a case, the unpaid seller's right of lien or stoppage can only be exercised subject to the rights of such transferee. Transfer by buyer and seller. When the unpaid seller who has exercised his right of lien or stoppage, he gives notice to the buyer of his intention to resell, The unpaid seller may, if the buyer does not pay or tender price within a reasonable time, he can resell the goods within a reasonable time and recover from the original buyer damages for the loss occasioned by breach. Where an unpaid seller resells the goods, the buyer who buys thereafter gets a good title as against the original buyer, notwithstanding that no notice of resale was given to the original buyer by the seller. Suits for breach of the contract. Suits can be for price, where the contract of sale, the property and goods has passed to the buyer. The price is payable on a certain day irrespective of delivery. The seller may sue the buyer for the price of the goods according to terms of the contract when the buyer wrongfully neglects or refuses to pay such price. He can also have a suit for damages for non-acceptance, where the buyer wrongfully neglects or refuses to accept and pay for the goods. The buyer may sue the seller also for damages for non-delivery, where the seller wrongfully neglects or refuses to deliver the goods. Specific performance is also available, asking the person to deliver specific or ascertained goods under provisions of Specific Relief Act. The court may direct that the contract shall be performed specifically without giving the seller the option of retaining the goods on payment of damages. Remedy for breach of warranty. Where there is a breach of warranty by the seller, or where the buyer treats any breach of condition by the seller as a breach of warranty, in either of the cases, the buyer is not entitled to reject the goods, but he may avoid paying the price for the goods which breach of warranty is observed and sue the seller for damages for breach of warranty. Repudiation of contract before due date. Where either party repudiates the contract before due date, the other may either treat the contract as subsisting and wait till the date of delivery, or he may treat the contract as rescinded and sue for damages for the breach immediately. Interest. As per contract or law, interest or special damages may be recoverable. To recover the money paid where the consideration for the payment of it has failed, in the absence of contract to the contrary, the court may award interest at such rate as it thinks fit to the seller for the amount of the price from the date on which price was payable, and to the buyer for refund of the price for breach by the seller from the date on which the payment was made. Auction sale. Where goods are put up for sale in lots, each lot is deemed a separate contract of sale. Sale is complete when the auctioneer announces in the customary manner, before which any bidder may retract his bid. On behalf of the seller, a right to bid may be reserved expressly. Where such right is expressly reserved, the seller or any person on his behalf may bid at the auction. Where the sale is not notified to be subject to such right to bid on behalf of the seller, it shall be unlawful for the seller to bid himself or through his associates, and it is treated as fraudulent. An auction sale may be notified to be subject to a reserved or upset price, where the seller makes use of pretended bidding to raise the price. The sale is voidable at the option of the buyer. Goods under Sale of Goods Act refers to movable property. Goods to be manufactured, produced or acquired by the seller after making of the contract of sale is called future goods. The contract of sale is an executed contract. In an agreement to sale, the transfer of property in the goods is to take place at a future time. An agreement to sale does not take place for existing and specific goods. In an agreement to sale, buyer is not entitled to recover the goods from the official liquidator in case of insolvency of the seller. The Latin maxim, nemo dat quod non habet, means no man can pass a better title than what he has. A condition is a stipulation essential
to the main purpose of the contract. On the other hand, the warranty is a stipulation collateral to the main purpose of the contract. In a sale by sample, an implied condition is that bulk shall correspond with the sample in quality requirements. The buyer cannot reject the goods where there is a breach of only warranty by the seller, but he may sue the seller for damages. Where the seller makes a false representation and buyer relies on it, the doctrine of caveat emptor doesn't apply because it's an exception to the doctrine of caveat emptor. Delivery means voluntary transfer of ownership of goods from one person to another. The seller of the goods is not bound to deliver them until the buyer applies for delivery. The buyer of the goods need not have to accept if the delivery is made by installments. Where the goods are refused by the buyer need not have to return it to the seller has to collect it himself. When once the property is transferred, risk also moves to the buyer, whether the delivery has been made or not. Property transfer is more relevant. If there is a refusal by the buyer to accept the goods and there is a damage to be claimed from him, and where no time is fixed, the damage will be the difference between contract price and market price on the date of refusal. Where the delivery has been delayed through the fault of either buyer or seller, the goods will continue at the risk of the party at fault. If the buyer or his agent obtains delivery of the goods before their arrival at the appointed destination, the moment they take delivery, transit is at an end. If the goods are rejected by the buyer and still the carrier continues to in possession of the goods, the transit of the goods is not at an end, it is still goods in transit. The right of seeking claim for damages is not an unpaid seller's right against the goods. The seller is deemed to be unpaid seller when the whole of the price has not been paid. The unpaid seller has the right of lien on the goods for the price while he is in possession of them. The contract of sale is not rescinded by exercise of right of lien or stoppage. Right of lien is the right to keep the goods in the possession of the unpaid seller. In an auction sale, the sale may be subjected to a reserve price or a setup price. A person who is employed by the seller to raise the price by fictitious bids is called puffer, bybidder, or decoy duck. Damping is an illicit act of dissuading the interesting purchasers from bidding or from raising the price by pointing out defects in the goods.